Good afternoon, everyone. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin, the Western Canada employment practice leader. I am joining you today to discuss your employment rights. Any questions you have related to your employment, feel free to put them in the chat. We're going to get to as many of your questions as we can here today in the next half hour. That's right, we are live to answer any questions you might have related to your employment, related to the law surrounding employment in Canada. So we operate out of 3 provinces in Canada. That's BC, Alberta, and Ontario. And we can answer any questions related to employment law in those provinces. Speaking of Alberta, which is where I'm located, we have the G7 summit happening as we speak here in, not far from here, in the Kananaskis region of Alberta. A lot is at stake. World leaders are discussing, amongst other things, the tariffs. A lot of Canadians have been impacted by these tariffs. A lot of Canadian companies, a lot of Canadian employees are impacted by these tariffs. We're seeing slowdowns in the economy. We're already starting to see plant closures and things of that nature. And that's really quite heartbreaking, frankly, to see people losing their jobs or being placed on a layoff as a result. A lot of people are asking us, well, what does that mean for me? What does that mean for employment rights? If, the reason I lost my job is because there are new tariffs, does that impact what I'm entitled to? Well, I can tell you right now that it does not. If you are terminated, be it because of tariffs or for some other reason, if you're terminated on a without cause basis, and you are entitled to full severance here in Canada, in Alberta, BC, and Ontario. And so it doesn't matter whether the reason is because there are tariffs coming in from the United States or whether it's some other reason for some restructuring or some downsizing. It's very unfortunate when that happens, both for the company and the employee, but the courts have been very clear that, that's a risk that the company takes, and the employee is entitled to what their employment rights are, which are to be provided with a reasonable amount of severance to ensure that they have something to tide them over until they find another comparable job. So that's what we're going to be discussing today. How much severance you might be owed. A question a lot of people ask me, Luc, I hear so many things. I hear it's 1 week per year. I hear it's 1 month per year. Can you give me some clarity? Well, the clarity I can provide is that it varies from person to person, and it doesn't just the factors are not only your length of service. There's going to be other factors that are involved: your age, the kind of job that you do, how likely it is that you'll find a comparable job quickly. Those are all factors that are taken into consideration. But we've done the guesswork for you. We've prepared a great nifty tool that we have called the Severance Pay Calculator. You can find it on our website at severancepaycalculator.com. You answer 4 easy questions, and we'll give you an estimate of what we think your entitlements would be for severance pay. Free of charge, no obligation, completely anonymous if you want it to be. Reach out, take a look at that, have an idea of what we're talking about, because I can tell you it's often tens, if not hundreds of thousands of dollars that are on the table here. You want to do a little bit of legwork, your own due diligence, to make sure you're not walking away from, a lot potentially of money that you could, use to feed yourself and your family, keep a roof over your heads when you're going through these tumultuous times that we're living through today. So we have a few questions that have come in. We have one question asking, I work for a company that makes a product. Until a few weeks ago, there was a dedicated sales team within the company itself. We were then told that the sales team was being folded and we could interview with the new company taking over. This is a third-party company with no ties to the original company. They now have the contract to sell our company products. We have since interviewed with the new company, but have been essentially told that if we take a position with the new company, that we will not be paid a severance package, even though we are in fact being laid off. Can they do this? So essentially, yes. All right. So a severance package, the purpose of the severance package, as I was saying earlier, is to tide you over until you find a new job. If your company closes down its department, but ensures that all its employees have a job somewhere else, then you have no losses from the loss of your employment because you're starting a new job the very next day. And so therefore, there's no need to pay you any severance. So that is theoretically correct. However, I see a few issues with this scenario. Once you get into the details, the devil's in the details, as they say. So is the job the same? Is it a comparable job? It's going to be comparable in terms, of course, compensation, distance from your home, duties and responsibilities, and level of seniority. Not seniority necessarily that they recognize your years of service, but seniority that if you're a manager, you're not being demoted to a salesperson and things like that, right? And if it's not a comparable job, then there's no requirement that you accept it. And if you don't accept it, then you're still owed severance from your old employer, okay? Now, another scenario, say you've been at your old employer for a very long time. You're one of those people that's entitled to 2 years of severance, which is the maximum you can get here in Canada. So you go work for the new employer and they terminate you within 6 months of starting your new job. That means you still have a claim against your old employer for the remainder of the 2-year period, right? So you had a job for 6 months, then you were terminated, and your old employer owes you 2 years of severance. So you still have a claim for the further 18 months of severance that you were owed. That's why it's very important if you are accepting a job with a new employer that you don't let the other company, the old employer, off the hook for severance, okay? So you shouldn't have to sign away your rights against the old employer to accept a new job with a new employer. If they're asking you to do that, it's important you contact us to discuss the offer to make sure you're not signing away your rights. It could be that the whole plan is to let you go very soon thereafter, after you've signed away your rights to go after the first employer for your severance. So make sure you consult with us before you sign any of that paperwork saying that you will not go after your old employer for your severance. If you're looking to reach out to us, it's very easy to do. You have the website right there on the screen. Go to employmentlawyer.ca. That's how you get in touch with us. So we can explain to you all the kind of different ways that this could go wrong so that you have your rights are protected, all right? So that you ensure that you're not being kind of left out in the cold. All right, we have another question coming in from YouTube from Lil Will. Lil Will is asking, my company wants me to move into a position that I'm not trained for and have no experience with. They want me to start showing up 2 hours earlier to train, but have said it's unpaid. Is this legal? They want me to work 10-hour days, but only get paid for 8. So Lil Will, no, it's not legal. Basically, you're supposed to be paid for all the hours that you work. Essentially, you can refuse to work unpaid hours. I didn't catch which province you're in, but if you're in BC, Alberta, or Ontario, if they are making you work and not paying you for the work you've done, then you can make a complaint to the Ministry of Labor. In Alberta, you go to the Employment Standards branch of the Ministry of Labor. You can either call them or make an application online. And they will investigate and ensure you get paid for all the hours that you work. And if your employer refuses to pay you, they will order your employer to pay you. All right. You can start off by telling your employer, listen, I'm happy to train, but it has to be paid. I'm not working for free. If you want me to take this role, you have to pay me. If you don't want me to take this role, leave me in my old role. I'm very happy where I am. Right? I'm doing you a favor here. So pay me for my training. We have a question from Mitzi. Mitzi is asking, hello, I have another question. My sister's employer has become very difficult after she announced her pregnancy. We think it's because of her upcoming leave. How do we deal with this? So Mitzi, it's there's nothing to deal with. In fact, essentially, if your employer is trying to make your sister's life difficult because of her pregnancy and her upcoming, maternity leave, that amounts to discrimination. Okay, so I'd like to hear a little bit more about what it is that they're doing to make her life difficult. But if it crosses a certain line, where it becomes either harassment or a constructive dismissal, then your sister is entitled to leave and require the employer to pay her, number one, severance for having forced her to quit, and number two, human rights damages for having forced her to quit because she was pregnant. Okay, so all of these options are available to your sister. I gotta get a better understanding of what it is they're doing to make your sister's life difficult. But if objectively it is a situation where they are either harassing or discriminating against your sister, she doesn't have to stay there and put up with it. There are ways to deal with it so that she can leave and still get the compensation she's owed, both under employment law and under human rights law. So the first step to do that is to reach out to us to discuss the situation, give us concretely what it is that they're doing to make her life difficult. To reach out to us, you have the number on the screen there. It's employmentlawyer.ca. All right, we have another message here from Dave Al, mentioning a name, Leah Klein. I don't know what that's relating to, Dave. You might have had a preceding post that I'm not seeing here. If you have some questions, Dave, feel free to just pop that back into the chat. I don't think it made its way through to me here. All right, we have another question coming in from YouTube, from Firebird. Firebird is asking, I work at a restaurant at a golf course. There's been a lot of problems with the chef, like consistently changing my schedule a day before I'm supposed to work, constantly running out of menu items, etc. I was wondering what is the consequences would be for walking out without notice. Okay. So if you quit a job, the certain provinces require you, depending on how long you've worked there, to provide 1 or 2 weeks of notice. Other provinces don't have that requirement in their employment standards legislation. So Alberta does have a requirement. Ontario, for instance, doesn't have a requirement. That said, you might have signed an offer letter or a contract when you started that might also set out how much time you must give of notice, all right, of resignation. Now, if you don't provide that notice, theoretically, the employer can sue you. Okay, they can sue you saying that you breached the terms of your employment by not providing the notice that you are either contractually or statutorily required to provide. Now, that may all well be true, but proving a breach of contract or a breach of statute is one thing. The employer still has to prove that they suffered damages, that they suffered a loss as a result. Okay. So the breach occasioned a loss. And that's where it gets kind of tricky for a lot of employers to prove that your departure resulted in a loss for them. Because number one, they're saving money almost automatically by not having to pay you. And so they have to show that the losses they've incurred are greater than the money they save by not paying you. All right? In certain jobs, like restaurants, it might be hard to show that they actually lost money by your absence. Now, it's not that I'm encouraging anyone to breach a contract or to breach a statutory requirement. All right, I'm just explaining to you what can happen. Now, even if they lose the lawsuit, it's never fun being sued. So it might be a lot less of a headache. It might be a lot less of a headache for you, Firebird, to provide the notice. What I often end up seeing in a lot of cases is you'll tell them, listen, I'm going to give you my 2 weeks notice that I'll be resigning in, say July 1st or whatever it is. And they'll tell you, well, listen, actually, that's fine. Don't come in. We don't need you any longer. Now, the question then becomes, well, I was about to give you 2 weeks of notice. I expected to be paid during those 2 weeks. You tell me I don't have to come in anymore. What happens to my 2 weeks of pay that's coming up? Well, that money is owed to you. Absolutely, right? You were willing to work an extra 2 weeks. They say you don't have to come in. Doesn't mean that they don't have to pay you for those 2 weeks. Absolutely, they have to pay you that amount. All right. So you may, by doing the right thing here, Firebird, provide 2 weeks of notice, be told stay at home for those 2 weeks and still get paid 2 weeks to stay at home. Sometimes you see it pays to do the right thing. All right. So think about that. But I definitely understand that, if this is a kind of a fire show there, that, it could be tough to stay there. And of course, if it's dangerous, if you're being abused or harassed or anything like that, that's a very valid excuse to not provide 2 weeks of notice, right? If you're just going to go to work and just, be put through the psychological ringer, absolutely. No, you don't have to go, okay? This is, you have a contractual or a statutory obligation to provide the 2 weeks of notice under normal circumstances. If you have people yelling at you, changing your shifts, making life hard for you, No, you don't have to put yourself through that just to comply with your statutory or contractual obligations. You can just say, you know what, this is enough. You guys are being awful to me. I'm not going to put myself through this. I'll see you when I see you, and just leave. All right. We have another question coming in from Sally the Slice. What a great name, Sally the Slice. Sally the Slice asks, I've worked seasonally for the last 12 years as a landscaper. The business owner is now saying he's going to shut down or sell the business. What are my rights? What rights do I have to take over the company if I've been the longest? Is a seniority factor in this at all? Okay, so I'll start with your second question, Sally the Slice. Before I answer the first, which is I don't think you have particularly any rights to take over the company. You can make an offer to the owner and see if he or she wants to accept your offer, but you don't necessarily have a right to take over the company, as far as I know, unless you have contractual terms that allow for that, right? That you sign a contract of some sort at some point that gave you the right to buy the company, to have a right of first refusal or anything like that. If you don't have something like that, there's no, in the law, a right for the most senior employee to buy the company when the owner decides to sell. Okay, that's just not a right that exists. However, say the employer decides to, can't sell the business, doesn't want to sell it to you, decides to simply shut down the business. Do you have any rights to severance? Well, the truth is, yes, you do, Sally the Slice. You have worked seasonally for 12 years, which means that at the end of the season for 12 years, you've been laid off. But you've been laid off with the expectation that you would be recalled at the start of the next season. So if they lay you off permanently here with no expectation that you'd be recalled at the start of the following season, then that's a different game altogether. That's a different beast altogether. And now, because they're laying you off permanently instead of temporarily, means that you're entitled to severance. Okay. So if you're entitled to severance, then you might be asking yourself, well, what kind of severance am I entitled to? That's a great question. We have the answer for you. It's on our website. It's severancepaycalculator.com. You have the email, the website address right there on the screen. All you have to do is answer 4 easy questions, and you will be provided with an answer of what we estimate your severance entitlements might be. So very important that you check that out so you have an idea of what your entitlements are, Sally the Slice, and the rest of you here listening today. It's important that we know what we're talking about when we're talking about, yes, we have severance rights, right? Because it can be, like I said, tens, if not hundreds of thousands of dollars. It can be a very large sum of money. You can get up to 2 years of your full compensation. So just think about it, calculate that. What's two times my yearly salary, including all components, including the bonus, the travel allowance, the benefits, the commissions, including all of that. What is 2 times my yearly salary? That might be as much as you're entitled to under severance. So you want to make sure that you understand what you're talking about when your employer is talking to you about, providing you with some severance. Are you getting what's fair in the circumstances? Very easy for you to do your due diligence. Very easy for you to find out how much we're talking about here. And all you have to do is visit that website, severancepaycalculator.com. And from there, if you want to speak to any of us, you're just a click of a button away to get in touch with us so that we can discuss with you. Now that you know how much severance you're entitled to, how do you go about getting it? And that's where we come in. That's where we can help. All right. We got another question coming in from K-Swizz. K-Swizz is asking, I was employed as a software developer for 8 years, with over 2 of those years working in Canada. Recently, I was placed on the bench for about 2 months due to no available projects. Done with just 1 week's notice, I was let go and offered only 2 weeks of severance pay. Is this normal, or should I expect more severance? So K-Swizz, what I can tell you is that normally you'd be entitled to more severance. If you were just listening now, you would just have to visit our website to figure out how much severance you're entitled to. But I can tell you right now, without having seen your contract, I can tell you why I think your employer is relying on a contract that says that only your years in Canada count for your years of service. And even if we only look at those 2 years that you're in Canada, there's probably a termination clause in that employment contract that says if you're terminated if this contract is terminated, you will only get certain minimum entitlements that you're owed under employment standards legislation. And that employment standards legislation usually provides in BC, Alberta, and Ontario for about a week per year of service, up to a maximum of 8 weeks. Okay, and that's why they're only offering you 2 weeks here, probably because there's a termination clause in your employment contract. It's more and more frequent. We see it in a lot more contracts here in BC, Alberta, Ontario. I want you to not despair. Okay, K-Swiss. You see a termination clause in your contract, your first response has to be, well, listen, I need to show this to Lluc or the good people at Samfiru Tumarkin. They're the experts in termination clauses. We know whether that termination clause holds water, whether that termination clause is valid, and I can tell you, in my experience, a vast majority, a very large majority of termination clauses have issues with them, which means if there's issues with them, then they're not enforceable, which means you're entitled to your full severance. Okay, so it pays to have us take a look at that severance clause, that termination clause, to make sure whether it's legally enforceable, and if it's not, what are your severance entitlements. Okay, so if you're looking to reach out to us to have us review that termination clause to give you an idea of what your entitlements might be, simply reach out to us, employmentlawyer.ca, and we will take a look at that clause for you and let you know what your rights are going forward. We have another question coming in from Griff. Griff is asking, my work has announced that there will be layoffs imminently. My employment contract states that I will receive 1 day of severance for every month worked. Is this normal? Would this hold up? I worked for 6 years, so the 72 days sound like a good amount. I don't know if I should accept an offer like this or should I get more. If you've been working 6 years, Griff, I think that probably your severance entitlements are, I don't know much about you, but are going to be in this. Generally, we're talking about a month per year. And so a month, 6 months is 180 days, right? So this seems a bit light. Now, I'm just saying that going on your length of service. And what I've been saying is throughout the show is there's a bit more that goes into the determination. And if you're looking to find out how much do we actually think your severance entitlement might be, Griff, it's right there, severancepaycalculator.com. 4 questions, you'll figure out what we think your severance entitlements might be. Anyway, you slice it though, I think a day per month is a very weird kind of termination clause. And as I've been discussing, a lot of clauses have some serious problems with them that render them unenforceable. So I appreciate that you've summarized the clause for me, but I will tell you it's important that our lawyers here actually read the clause in the entirety of the contract for themselves. All right. So what I would say, Griff, is if you use our severance pay calculator and see that you're entitled to a lot more than what your employer is offering you, get on the phone, get on our website, reach out to us at employmentlawyer.ca, schedule a consultation. We will be happy to look at that termination clause at your severance offer and let you know whether we think that you got a fair amount or whether you are owed a lot more. Okay, you owe it to yourself. Go take a look at what we estimate your severance entitlement might be, and you'll see that you owe it to yourself to do a bit of due diligence. Get in touch with us, have a professional lawyer review your severance package and your employment contract and let you know whether that's a fair amount or whether you're entitled to more. We have a question coming in from YouTube from No Fall. No Fall is asking, I worked for a small business last year. The owner of this business fired me without pay or explanation and refused to pay me my termination, claiming I wasn't fired despite removing me from the schedule and generally shutting me out of the store. I just learned today that he has been spreading rumors that I was viewing certain materials at work. I was not, and anyways, I find it highly embarrassing and inappropriate for him to be saying this. The industry this is in is a small one. Is there anything I can do? Okay, so a few things to unpack here, No Fall. So firstly, you were terminated last year without any severance. And secondly, now the employer is spreading some rumors about you. Okay, so those are 2 different claims. Okay, So if you were terminated last year with no severance, you can make a claim against your employer for severance. You can say, well, listen, you didn't use the words you're terminated, but you locked me out of the store, locked me out of everything. I couldn't go to work and earn and provide work to you in exchange for compensation. It means you terminated me, basically. And so if you terminated me, you owe me severance. Okay, so that's your claim number one. You might be asking me, well, how much am I entitled to? So no fall, very easy. Just go to a severancepaycalculator.com and calculate how much severance you might be owed. And then if once you see that, you'll be able to see whether you want to reach out to us and discuss how we go about getting that severance for you. And claim number two is that they're defaming you. So this seems to be a defamation claim. The challenge with defamation claims is always proving that they've actually said this. So who is, the rumors? I'm not a huge fan of rumors. Rumors are very hard to prove in court. But if you have someone who will vouch for saying that they have heard this employer, this former business owner telling them specifically about these lies, then you would have a claim in defamation. Now, defamation is not necessarily something I do a lot of. So I couldn't tell you how much you might be owed. There isn't a defamation pay calculator that I'm aware of. But you'd have to reach out to someone who does defamation law if you can prove that these statements were made. Okay, that's number one. You have to prove that these statements were made. Just rumors is not going to cut it. So you need to have someone who can say, yes, I heard this business owner tell me that No Fall was looking at inappropriate documents or inappropriate content on the web while he or she was working for me. If you hear that, that means that now that employer has to prove that. And if they can't prove that, and you can prove that that kind of statement would bring you into disrepute in the eyes of a reasonable, normal person, then you're starting to be able to prove that you're owed damages because they have defamed you. Okay, so definitely first step there is finding out who can I rely on to say, yes, this is what this gentleman is or this person is going around saying about me. And we have a comment from Griff. Griff was the one who had the day per month of service. And Griff is saying, thank you, sir. I will reach out. I have some coworkers who are in the same boat. Definitely, Griff, reach out. Have your coworkers reach out. It's important you guys know what your entitlements are. All right. And so we have time for one last question. Thank you all for listening in today. These have been some great questions today. I really appreciate you guys putting putting in the time to ask your questions. There's very thoughtful questions I got from you today. I have a last one coming in from Samuel. Samuel is saying, if your employer revokes travel coverage compensation for kilometer drive, should they increase your pay to compensate? Is there any regulation on their end to deal with this? So what I'm hearing, Samuel, is that you got some sort of travel allowance, so some sort of mileage allowance or something like that. And now the employer is taking that away, and you are saying, well, I should get that. They shouldn't be able to just reduce my total compensation. If they're going to take away the mileage, they should increase something else, like my hourly rate or my commission structure or something like that. So here's the thing, okay? Employers can make small changes to your employment, including your compensation, without your consent. There's no laws that says they can't, so long as they're paying you minimum wage. But they can't make big changes to your compensation without your consent, okay? What does that actually mean? That means that if your compensation, you have to calculate how big of a percentage of your total compensation is this mileage allowance. Then you have to ask yourself, so this is a certain percentage, let's call it 15% of my compensation comes from this mileage allowance. Does that make it a small change or a big change to my compensation, them taking it away? All right. So it's a factual question, but generally I can tell you 15 and up, even maybe a bit lower, 12 or 10 and up, can amount to a kind of change that they need your consent. If it's less than 10%, unless there's something else involved with it, unless they're saying, and we're going to demote you, or they're saying, and now you're going to have to work from the office. If there's nothing else, if it's just that they're reducing they're taking away the mileage allowance, It's probably a small change and they don't need your consent for it. If they do need your consent, how do they actually obtain your consent? Well, they can make the change, and then it's up to you to decide whether you accept it or not. And if you don't accept it, what you do is you quit. Tell them, you forced me to quit. Because of that, I am going to require you to pay me my severance. And my severance will be based on my full compensation, including what my mileage allowance was before you changed it. Okay, so the first question you have to ask yourself, Samuel, is am I willing to quit my job and pursue my severance over this? And if the answer to that is yes, then I think you should get in touch with us so we can tell you whether this is a big change that requires your consent or a small change that doesn't require your consent. And once we've decided that it's a big change that requires your consent, we can explain to you how you go about getting out of there with a severance package. Okay? So what I can advise you, it sounds a little bit complicated. You might not have understood everything I said. That's because it is a bit complicated, and I strongly advise you to try to reach out to us before you make any drastic decisions, okay? So reach out to us at employmentlawyer.ca so that we can help you navigate these tumultuous times so that you can get to a point where you are in the position that you want to be, okay? That's it for today. My name is Lluc Cerda. I'm the managing partner of the Calgary office of Samfiru Tumarkin. I am the Western Canada employment practice leader. I was here today to answer your questions about employment law. Thanks again for all those great questions, for your thoughtfulness in putting those questions together. We have another show starting tomorrow at 1 p.m. Eastern with my colleague Sefton Liebrandt. He's going to be answering your questions as well. If you didn't get any questions in today, or if you have some follow-up questions, ask Sefton tomorrow, 1 p.m. Eastern. He'll be there to answer any questions you might have regarding employment law. Thank you all for joining. It's been great speaking with you, and we'll see you again soon. Bye now.